At the very bottom of the screen, you're going to see the turn from Huron River Drive onto Superior. Up top of the screen, sir, you will not disrupt these proceedings. I do not want to kick you out, but you are not going to disrupt these proceedings. Up at the top of the screen, you'll see the railroad tracks. And if you look at, I think the first, if you look down from the railroad tracks off at Superior, that first street coming off, which would be as you're looking at the screen to the left, that's First Street. From there, you can see that there is a clear shot to that intersection with the railroad tracks. If Mr. Torres is there, he has a clear shot to that whole area. When you also look at it just in terms of his timing of the calls, the other calls that are coming in, he can't not be in that area and see what happens, because the other calls come in shortly thereafter, and they're traveling north from the Gettys area, traveling southbound on Superior. They see it. So again, I'm not here, I don't. I'm not here to worry about what's charged, what's not charged. I have to mete out the best sentence I can with what I have. And I will let you know, and counsel, I will give you an opportunity if you want to somehow or another speak with your client prior to the court imposing sentence. But I do believe that jail time is appropriate given what I see. I can't, in giving that, I can't bring back these young ladies. And I told the parents, I can't do that. But I certainly can do the best that I can to make sure something occurs. If I believed that Mr. Torres was not present, that it was as it was portrayed to this court, a circumstance where he could not have seen it, that he would have been so far down on Superior that he wouldn't have seen the railroad tracks, then that's where I would land. And I would have no problem landing with that and justifying it. I can't, based upon his own statements, justify that as being true. He had to see it. He's telling me he's 2 to 3 cars behind them, that he's following them, and that he's at first, and it's a clear shot to those railroad tracks. If somebody wants to tell me how I can come to a different conclusion, then please tell me that. But I can take into account in terms of sentencing whether or not a defendant is being truthful with the court in terms of what they're saying. And I will be blunt. I'm just a plain talker. I don't believe that he is. Counsel, if prior to your, Mr. Torres is, I don't know that you can see him or not, he really wants to make a statement, I will arrange, counsel, I know you don't want him to, if you want, because since you're not here, if you want to talk to him, I will arrange to get him on a Zoom and get you guys into a breakout room so you can talk.
No, Judge, that's fine. I'm ready to make a comment when you're ready to hear it. I don't need.
Oh, go ahead. Sir.
Judge, with all due respect, this is wildly inappropriate. For you to be doing an investigation on your own, for you to be
So,
pulling
hold
up.
on, counsel,
Go ahead, Judge. You're the boss. Yes,
counsel,
Judge.
stop a moment. I think I acknowledged that. I'm not here doing an investigation. The question is what was represented to this court is that he could not have seen it, that he was not following that. Anything that I have here is not an investigation. All I did was listen to the 911 and read the police report. So in that case, if you think that's inappropriate, then fine, you can go ahead with your statement. And then I will proceed to my sentence.
Right. In addition, Judge, you pulled up a map and you said that it's impossible to see, and it's possible to see where the accident was without actually being at the scene viewing it. There was no trial. There was no any opportunity for the defense to present you with counter evidence or anything like that, Judge.
Counsel, what do you want to give me? What do you want to give me?
I don't want to give you anything.
What do you want to give me? No, Judge, counsel, if you're going to say I'm being unfair, what do you want to give me?
Judge, I want to tell you that I don't believe you should be considering anything that occurred after that.
What you represented to this court, and I realize you're advocating for your client about him being someplace further from that scene, it's not true. It's his own statements. These are not anything where I went out there and I'm looking at something or I'm doing whatever. It's just placement. He's saying he's at first. I just listened to the tape. I didn't do anything. I didn't go out there and investigate, talk to any witnesses, do anything like that. I did that and looked at a map. That's all I did.
Right, Judge.
So if you want to give me something, counsel, you can come here 2 hours late. Give me what you want to give me.
Judge, I don't believe you should be considering anything after the fact of the initial accident. He's being sentenced for failure to stop at a PD accident. It has nothing to do with what he did afterwards. It's completely inappropriate for the court to be.
What he did afterwards?
After the accident, when he was initially rear-ended, that's what he pled to, failing to stop at that accident. It's not failing to stop at the accident that the girls were involved in. It's failure to stop at the accident where he was rear-ended. Ms. Reiser agrees.
If your client, knowing what I'm going to do, wishes to withdraw his plea, I will consider that motion.
Judge, I would also ask that you recuse yourself at this point.
Denied.
Understood. And I can, if you wouldn't mind allowing me to speak with Mr. Torres, my guess is he's going to withdraw his plea.
I'm sorry?
If you wouldn't mind allowing me to speak with Mr. Torres to make sure this is going to happen, but my guess is he will withdraw his plea.
Can we set up a breakout room for Mr. Torres in signing on to Zoom in one of the conference rooms? Mr. Torres, we're going to put you into one of the conference rooms out there. We're going to put that machine into a breakout room and put your counsel into a breakout room so you guys can talk. Court will stand in recess. We're back on the record in the, is everybody here? Yes, they are. We're back on the record in the Torres matter. Had an opportunity, well, first of all, that counsel had an opportunity to speak with his client. It's been also an opportunity for the court to speak with counsel. They are going to consider a motion to withdraw the plea or the other end alike. The court is going to give the opportunity for them to file the written motion to do so if necessary. I'm not saying that that's what they're going to do, but give that opportunity. So I'm going to adjourn these proceedings for the motion as well as sentencing. I'll set both at the same time to March, my next sentencing, March 13th. And I want a special time so that
3 p.m.
All right, March 13th at 3 p.m. for a continuation of the proceedings. I have directed counsel that everybody needs to be in person at that proceeding.
Understood.
All right, bond will continue. Thank you.
All right, thank you, Governor.